Perfect. So thank you everyone for joining. Thank you so much for your time with us today. So my name is Laura Geftos. I am the Program and Events Director with the Michigan Hispanic Chamber of Commerce. And I have my team here with me today as well, Patricia Nava and Mark Moreno. And then next to me, I have Laura Huber as well. Just not on camera. And I want to thank Michael Burns. He is the Executive Vice President with ASC, who's bringing us this relevant topic today. I'm sure you all have heard it. If you run a staff or if you have a staff, have a business with team members, you know of this very important act that came through February 21st, which is the Earned Sick Time Act. And I believe there's been many of changes, many unanswered questions ever since it came on board. So with us today, we have an expert, Michael Burns, who's going to be answering some questions, a full presentation as well. Some of your questions that were submitted ahead of time will be answered during the presentation. And we're going to leave some Q&A section at the end of the presentation where we could ask any unanswered questions, anything that's unknown, and Mike will help us navigate through that. So with no further ado, go ahead, Mike. The floor is yours.
Well, thank you very much, Laura and Mark. I really appreciate the opportunity to present to the Michigan Hispanic Chamber of Commerce and its members. I don't know about you, but at ASE, we focus on HR, and it seems like this has been going on, and it has been going on literally for years. Um, but for most of us, in terms of setting up policies and getting things going, we've only been working on this, it seems like, for about a couple months. On the other hand, what I'm going to do today is talk first about the history, kind of remind you of, where this law came from. And by the way, Michigan's not alone with this law. There are about 15, 16 other states that have comparable laws on paid sick time, and they all have little different quirks to them. Michigan, by the way, is, as a state, one of the most generous in the country. Most of the other states' laws provide about 50, 60 hours of paid sick leave per year. So I know of one locality, and it's not just the states, by the way, that have these paid sick time laws. It's also certain cities. And if you're out there in California, they've got several different paid sick time laws throughout the state. But West Hollywood, of all places, offers, if you had employment there, up to 96 hours of paid sick time for employers in that area. So there's a wide variety of laws out there for those of you who may be a multi-state employer. Keep that in mind. Okay, just a brief history. If you didn't know this, or if you've maybe forgotten over the years, these two laws, and I'm speaking not only of the Earned Sick Time Off Act, but the minimum wage law, started out as ballot initiatives. They were introduced by an outstate organization that wanted to push paid time off and minimum wage increases. And they got the signatures in the state of Michigan to put this on the 2018 ballot. What happened at that time, and this is because the Republicans held what they call a trifecta in the government. Back then, Governor Snyder was a Republican, and the two legislative houses under Snyder were also Republican. And at that time, that allowed them to the opportunity to do what they referred to as adopt and amend. Now, adopt and amend was supposedly a legal tactic that the legislature could take a ballot initiative and actually pass it as law. And then subsequently what happened was the legislature and the governor's office amended it. And what we got at that point was the Paid Medical Leave Act that most of us have been under. Now, if you're under 50 employees, you haven't had to worry about paid time off all this time. The Paid Medical Leave Act provided for 40 hours of paid medical, but you had to be over 50 employees to have to worry about that. Immediately after this adopt and amend occurred, legal challenges started. The question of whether that tactic was constitutional was taken up by the courts. It worked their way up to the Michigan Supreme Court. And in 2024, last summer, the Michigan Supreme Court found adopt and amend was unconstitutional. And what they did at that time was say, look, because the additional ballot amendments were what was the people wanted adopted, and what you had to adopt, at that time, we're going to use those as the law going forward in Michigan, but we're giving employers 6 months out to February 21st to get things ready to go. During that time, when it became apparent that a lot of small employers would be impacted by the new ESTA law. And I think that this got a lot more, although in our world at ASE, we don't have a lot of very small employers, and we certainly don't have restaurant or hospitality. But for those of you who may be in that industry, the more concerning law was the minimum wage, and more specific than that, the Tip Wage Act, which I'm going to cover a little bit at the end there. But for most employers, the big change was going from this Paid Medical Leave Act that for large employers provided 50 or 40 hours of paid time off to what we have today, the Earned Sick Time Act, which covers all employers. All employers pretty much in Michigan are covered by this except the federal government. So if you're a federal government employee, you are exempted. It applies to most employees within an organization. Now, there are some exceptions, unpaid interns and students who are there learning maybe the business and such, again, unpaid, they're not covered. There's also an exemption for a very particular classification of employee that pretty much amounts to an independent contractor. But if if you have employees that can absolutely set their own hours and have total control over their scheduling and so forth, they might be as exempt as well. But for all practical purposes, full-time, part-time, seasonal, temporary, exempt, non-exempt, all these employees must be covered under the particular ESTA program that your size in employment would dictate. Now that means that what the law says is if you have 11 or more employees, you have to pay 72 hours of ESTA paid time off. If you have 10 employees or less, you can provide only 40 hours of paid time off. And that doesn't go into effect for very small employers till 10/1/2025. So small employers have a short period of time where they can additional time where they can get their paid time off program going. Now, what the law first said back when they put the ballot initiative in as the ESTA law is that employers must accrue paid time off at a rate of 1 hour for every 30 hours of actual work. Keep in mind, and I'm going to clarify this, the accrual is not capped, but the use of PTO by an employee is capped. So what this compels, and I'm going to talk about front loading in a minute, because that was something that many employers thought they could do. And then when the law was amended the night before ESTA was taken effect, they recognized front loading, which I think a lot of employers are looking to adopt because there's some administrative convenience in doing it that way. So, but let's stick with the accrual. The accrual you must adopt if you don't go front loading is 1 hour for every 30 hours of work. The accrual again is not capped, but so that means if you're in the accrual method and you do not go to front loading, you will have to you will have to continue to track that accrual at 1 hour for every 30 hours worked. that's a bit of an administrative burden. And we did have a question, what's the advantages of front loading? One advantage of front loading of that approach is you don't have to track accrual. Okay, and I'm going to again talk about that in a bit. More closer than or sooner than in a bit here. The law provides for accrual and front loading. Originally, it did not. When you the law also requires under the accrual method uh, carryover of unused but accrued PTO. So this is where that accrual comes into place. If somebody, you know, uh, accrues so many hours and it caps out at 72. And by the way, this year, if you started your PTO program as of the 21st, they're never going to get near, unless they work a ton of hours, that 72-hour cap. But because the accrual method allows for a continual accrual, and if they don't use that accrued time at any point this year, they would presumably be able to carry over that accrued PTO into 2026. Here's another tracking issue. So you got this accrual going on, and you're also having to track the usage of that accrual. Okay, so you're going to have that particular administrative burden, I'll call it, throughout the year using the accrual method. And again, the ESTA law requires the employer to allow carryover under the accrual method. Under the front loading method, and let me just clarify what that is. What is front loading? That would be where you say, look, I have to provide you 72 hours, employees. Instead of using the accrual method at the start of, in some cases, the employee's anniversary year, okay, anniversary, or in most cases, employers are going to a calendar year. We're going to provide for 72 hours, given we're over 11 employees. We're going to provide for 72 hours right up front. And if you use this approach, it has the convenience, as I've said earlier, you don't have to worry about tracking accrual then. And it's a use it or lose it approach to this law. So if they get to the end of the year and they still have some ESTA time that they haven't used, you don't have to carry that over under the front loading method. Now I'll warn you, and I think a lot of employers who have to, you know, handle attendance and absenteeism all the time, people will do what you pay them to do. So if you front load, you're probably going to get a lot of employees using that time as they would like to. Okay. You do have, by the way, and this particularly if you, and we're going to talk about one bucket and two bucket ESTA. Okay. Think about the challenges you have around employee attendance, because each one of these methods have some pros and cons to them around attendance that I hope to hit on there. And if not, please remind me. I'll be glad to come back and go over that and talk about it. So, excuse me, going the wrong way. Before we get into a lot of other detail, what the law says there's certain specific reasons for the use of ESTA, and this is important to keep in mind. We're going to talk about a one bucket approach where an employee puts all their PTO in one bucket, and the idea there is, I'm not going to worry about how they use this, but you know, and they have enough time that I provided them. We're going to put it all together. What do I mean by it? We're talking vacation time, sick time, personal time, and everything else. Now, you do it this way, that's fine, but you'll have people using this ESTA time that they presumably are only using it for these reasons here, which are the employee or the employee's family member's physical or mental illness, injury, or health condition. This also includes preventative care. So, you know, going to the doctor's office and so forth is part of ESTA. Victim of domestic violence or sexual assault. That's both in the realm of physical violence and as well as psychological. It is also, ESTA is also there for the school or place of care meeting related to the child's health or disability, closure of the employee's business due to a public health emergency. COVID was one of those, and care for a child whose school or place of care has been closed due to a health emergency. These are the specific uh, items that ESTA requires time off to be provided. But as we know, there's a lot of other reasons for time off, and you're going to have to think through what would work for your organization in terms of non-ESTA time off. Think in terms of, the car didn't start this morning. That's technically not an ESTA covered attendance issue, but it happens quite frequently. So all those other reasons, a traffic jam, whatever, you may require a broader PTO program. And that's where it gets into the question of, do you want a one bucket PTO, which covers everything and just let them use it as they like? Or do you want to go with a two bucket or more PTO program? What does that involve? Well, a lot of employers are saying, I don't want to have my employees just taking and using this ESTA time for whatever they want. I'm gonna put that into a separate bucket, in which case you can require them to use that ESTA bucket just for these reasons here. Question I have is, okay, how do you handle the other issues? Well, that's where that second bucket of paid time off might come out, where the employer provides not only vacation, maybe sometimes they put bereavement in there. Sometimes they put other types of leaves, as well as those emergency situations that, again, don't fall under ESTA, the broken down car, whatever other emergency comes up that isn't covered by these reasons here. If you do it that way, you have the opportunity to provide, I guess, time off, paid or unpaid, in any fashion you might want to do it, as long as you're covering the ESTA required paid time off. We had a question that was submitted. What are the benefits of front loading? I've covered this a little bit. Of course, no carryover, not required to pay out unused or sick time at the end of the year. It's a use it or lose it. And if you have a group of part-time employees, you got to keep in mind a couple of issues here. You may front load with part-time employees at a pro rata basis, but you should provide the employee a written notice on how many hours you get and how to use those hours. The amount of hours front loaded is at a minimum, and this is what you got to do a little calculations with how many hours the part-timers are scheduled to work. Divide that by 30, and that gives you an approximate pro rata to front load in that method. And don't forget, if the employee suddenly kicks up their hours to more than that schedule, those also must be accounted for and paid out if you are to provide a front load system to part-time. I know a lot of employers that I've talked to, they're setting up a front loading for their full-time people, but they're doing the accrual method for their part-timers, which makes sense because now you can track more accurately to the amount of time the part-time employee actually gets. And again, you're using that 1 hour for 30 hours for those part-timers. But you can front load for part-timers if you want. You've just got to calculate what the pro rata would be. And let's just say you might calculate 5 or 6 days for the full-timers from now to the end of the year because of their schedule. The part-timers might only get a couple 3 days given their regular schedule at a 10 or 15 hours a week, if that's the case, as an example. So a lot of different ways you can go, and which has been kind of hard to, I've had a lot of our members ask, can you send me a sample policy? Well, we've got to factor all this in. There's no such thing as a sample policy or a one size fits all sample policy in this particular case. Keep that in mind. Getting back to the one bucket, there is the ability to put all your PTO into one bucket. It's called a general use PTO program. Excuse me. And employers can provide combined bank of paid time off that would apply to vacation, sick time, and so forth. But what you have to do in order to comply with this is the policy must provide at least the same benefits as provided in ESTA. So you have to make sure that in your single bucket general use PTO program that the use of the, let's just say you're over 72 hours to make it easy, those hours have to be set up and directed towards ESTA. Okay, they can use them for anything they want, which I think is a lot of the administrative makes it easy to use this one bucket. But you have to make sure that from the employer side that you provide at least what the ESTA law requires for that for those particular hours there. The hours may be used for the same purposes under the same conditions and accrued or provided at a rate equal to or greater than that described in essay. I think I just said that in a different different way there. So that would be kind of your one bucket. But remember, if you're using that one bucket, you're basically have to maintain accrual of the ESTA time off that they earn at 1 hours for 30 hours work. Unless, of course, you do the front load. But a lot of employers that I've talked to, when they go to the one bucket, they're trying to control. They're in an organization where attendance is a real issue, and they want to make sure that they're not providing more time off than they necessarily can afford to. So this gives them a little bit more control. So when we talk about the reasons for time off, we have to be talking about who is the family member here. And this is something that was a little bit surprising when they rolled out this law here. You'd expect at the top there that family would be considered child, parent, spouse, grandparent, grandchild, or your sister or brother there. But it also includes domestic partner, okay, and this is where it gets pretty wide open, any other individual related by blood or affinity whose close association with the employee is the equivalent of a family relationship. Boy, does that open it up to a big crowd. And how does an employer really, challenge or question that type of relationship? So keep that in mind. And when people start using these ESTA time off, that you're going to hear a lot of different, situations. I used to get a chuckle, and I hope I'm not offending anybody, but when we were applying the bereavement policy, sometimes somebody had 5 or 6 grandparents that passed, I mean, it's tough to really get into the rationale there. So again, we're going to be challenged as employers administering, this part of the law too. How small a increment may an employer is the employer required to allow to be used under ESTA? Well, originally it was either the smallest increment that your absence policy would permit, and if you didn't have a timekeeping system that did that, you could use 1 hour. What the amendments did on the eve of the ESTA on February 21st was change this to give employers the choice. They have the choice to say, no, I'm not going to provide or worry about ESTA and increments less than 1 hour, which I think a lot of employers are going to. But you have, as an employer, the choice to actually say, okay, I'll give you the time off in the smallest increment that my payroll system would allow me to account for. So you do have that choice. I think most of the employers that I know out there are, looking at it in terms of a 1 hour thing versus worrying about increments of time. But keep that in mind. Documentation. Here's where a lot of employers are scratching their heads and losing, I think, some sleep. The law states that employees may be off for 3 days without technically notice or documentation. Now, having said that, when we and unfortunately our friends at LEO, the Labor and Economic Opportunity uh, Department, clarified this and said, look, if you're going to, you as an employer, if you put in a formal notice system and give your employees written notice that this is what you expect on them, you can basically require and compel them to call in at their soonest convenience or soonest practical, reasonable time that they can do this. And I'll provide you a little definition there. This does not mean, and this is a challenge in terms of this law, this does not mean employers can just go, okay, you didn't come in for 3 days, I didn't hear from you, you're fired. You're going to have to do a little inquiry into those situations. And this is they don't have to provide necessarily documentation unless you request it per that formal uh, until the fourth day. At the fourth day, you can ask them to bring in reasonable documentation. They have to go to their doctors. You have 15 days to do this if when you make the request. But the quid pro quo is, employer, you're going to have to cover out-of-pocket costs to obtain for that employee to go in and get that documentation. Okay, so that means a lot of things, mileage possibly, of course, if they have to pay a medical visit cost for doing so, and so on. But that was something that that made it into the amendments. Excuse me. What am I doing here? Okay, giving notice, very important component. Um, if the notice, if the absence, I should say, is foreseeable, you can require the employee to give you at least 7 days notice before the absence there. The big thing is the unforeseeable absences. You know, somebody gets sick, somebody has to take a child to the doctors, whatever that falls under that those reasons for taking it off. Those are all those last minute unforeseeable absences. Here's where the employer can take a little control back. You can require notice as soon as practicable, which is kind of wishy-washy there. Or if you develop a policy that requests the employee to provide you notice within a certain period of time. This puts, I think, all the formal notice requirements, given that they're communicated. This is, and I want to stop and say one thing here. When this law went into effect, we had 30 days to do two things. Put up our ESTA policy, when this is coming up on the 23rd, I believe, putting up our ESTA policy and posting the required poster from the Labor and Economic Opportunity Department. Go to that site and you can download their poster there, not only in English, but Spanish and everything else. They got a lot of number of translator posters that are in different languages there that you can put up, given the makeup of your organization. But go there and get that policy, put that up by the 23rd, and you'll be okay. Otherwise, there's $100 fine for that particular violation going forward. So it's real easy to download. It's an 8.5 by 11 poster, and just as an aside there, before I get beyond it and forget to mention that. So you can write up a formal policy in terms of notice, and you can enforce that, provided that on the date of hire, when some new people come in, or the effective date of the act, whichever is latest, the employer provides the employee a written copy of the policy. Okay. It must include the procedure for how the employee must provide notice, calling in, whatever your process is, and that the notice requirement allows the employee to provide notice after the employee is aware of the need for earned sick time. So it's not something that you can say you got to have this in before. You can basically call after, and keep in mind, you've got to avoid any perception of retaliation. So there's going to be, and this makes what I call no fault systems very difficult to manage under this law. What is a no fault system? That's your point systems. You came in late, you got a point against you. You came in, you were at absence, unscheduled. We're going to give you a 2 points against that, and it adds up. And at that point, when they hit 5, 6, 7 points or whatever the system calls for, they go through the disciplinary process, or worse, gets let go. So you're going to have to make sure that under ESTA that you allow for the ESTA time off, and basically not penalize them for ESTA time off under any no fault system. So that's kind of a challenge there. So what I've seen in terms of policies being developed under that is that they will put qualifying language in terms of how the points are acquired. If this is an unscheduled absence, and down the line it says pursuant to Michigan ESTA law, basically telling the employees that if you let us know and you're complied with the notice requirements, you didn't violate it. This is a forgiven absence under our no fault system. So it, keep in mind if you have these systems, you gotta, whatever they are. And I got a question this morning that I'm noodling. An employer wanted to reward early arrival by way of a bonus system. Now, the question is, not to get too far off there, but the question is, in that little system there, if you're late, if you arrive at or earlier because of an ESTA issue, technically retaliation would occur anyway. With I think under this no retaliation rule, if you took that opportunity to get that incentive award away based on the use of ESTA. These are a lot of the nuts and bolts questions that are coming up that I ask you I bring it up just to think about, because you got to avoid this retaliation in under ESTA. Big thing to keep in mind: ESTA employers do not have to pay for unused ESTA PTO when the employee leaves the organization for any reason. But as I said earlier, this will be particularly true with a front loading method. If they see themselves leaving, expect some attendance and ESTA call-ins before that happens, because people will do what you pay them to do. Therefore, accrual might be a little bit more practical if you have a concern about your employees. I would also counsel at this point, this is a great opportunity to sit your supervisors and managers down and go over attendance policy. I bet you there's several interpretations of your own policy by your supervisors if they were being honest with you and as to how they would apply that. This allows you to sit down and say, look, this has to be done in this way because of ESTA. But by the way, if you've been allowing people to looking the other way for attendance or tardiness, we've got to tighten this up. It's the only way this is going to work, and we don't lose a lot of productivity because of attendance time up. Sorry, people, I'm on management side, so I've got to say that. ESTA allows an employee to bring a complaint with the Labor and Economic Opportunity Department. Originally, this was something that a civil action could be brought against employers if they failed. And now you had the plaintiff's attorneys, and I can be disparaging against all attorneys because I'm one of them. You can basically see how they were salivating over this civil lawsuit. This was taken away, I think, at the last minute when all the horse trading was going on to amend this law, and we got it down to where this is just a complaint situation. So if a violation occurs, you retaliated, you didn't give me the time I earned, whatever it is, they can make a complaint to Leo. They have up to 3 years from the time that alleged violation occurred. And Leo will do the investigation now as opposed to an aggressive plaintiff's attorney. But the fines involved for violation of this would be 8 times the employee's normal hourly wage. and or a violation of $1,000 if you engaged in retaliation. So again, make that inquiry into why the employee maybe didn't follow your notice requirements, get their explanation, document it, and then make a determination whether or not that you can follow through with some kind of discipline and not cross the line into retaliation. So, what should we do as employers in terms of preparing for this? I mentioned earlier, post your ESTA posters, get it on the Leo site, get it up by within 30 days, which I've got March 25th. I think really you should have it up by the 23rd. This is another thing, folks. There's no ESTA police out there, so they're not going to come banging on your door. But that said, and thank God you didn't have plaintiff's attorneys asking whether you did X, Y, and Z. But get this up as soon as possible, as well as revise and update your attendance policies and get your ESTA policy going. Provide written notice about your attendance system at the time of hire for new employees coming in, and this is another particular item that you need to have out there with your existing employees by this week. How to do this: review and revise existing policies. Everybody thinks in terms of the ESTA law, I got to have an ESTA policy, but think of all the other policies that come into play. Not only attendance policies, but call-in policies. What else have I seen? Well, check out your termination policy and make sure that you don't have a black and white 3-day no call, no show policy. Modify that one, because I know a lot of employers have it, and make sure that that says we may terminate your employee versus we will terminate if we don't hear from you 3 days, no call, no show, because again, you cross that line into possible retaliation. Train your supervisors and managers, as well as if you have an HR person, get them up to speed on the ESTA law. There's a lot of ins and outs. Update your attendance and notice policies. Talked about that. You got to make a decision as to whether you want to be a 1-bucket PTO or a 2-bucket PTO for ESTA purposes, and craft your policies that way. Make sure your policies are not inconsistent with the law. You'll develop these up. There's a few ins and outs with that particular law that you want to make sure your policies don't misstate. And keep an eye on the Labor and Economic Opportunity website. That's michigan.gov. And they have a great FAQ section there. They're making changes. We got a small adjustment to this, to interpretation of the law just this week, trying to better define what they meant by, they had this language in there that really described independent contractors. And I think I mentioned this earlier. I know I did, where you have employees who are exempt, who have the ability to set their own schedule. They have they can be exempt from coverage of ESTA there. So now we're waiting for any further clarification from Leo. We'll probably continue to get dribs and drabs of that. Keep an eye on that site. And then down the road, we'll undoubtedly, because there's 3 or 4 big sections of ESTA that'll be challenged, that Leo's taken a position in one direction that's very generous, beyond the scope of the law, and I think employers will challenge it. One interesting thing that threw everybody for a loop, and I don't know whether you caught this, was the original law, ESTA law, had nonprofit agencies as an employer, right? What happened in the amendments is they did a cross out of nonprofit agencies, which to those of us out here and to legislative wonks meant that they had just exempted all nonprofit agencies from coverage under this law. A week later, Leo said, no, they didn't do that, even though that's the way it's supposed to work in terms of amending legislation. When a crossout occurs, that means that's gone. What they did was, if you stood back and you just read the definition of employer without that nonprofit agency, it still clearly, or at least stated covered nonprofit agencies. So we had to do an about face about a week and a half later in terms of our understanding of that particular problem. We think that'll be challenged. I don't want the nonprofits to think that they're not covered under this act and be that test case, which could happen. But in any case, that was one of like three or four items that will probably end up in courts eventually, one way or the other. Very quickly, we had also that minimum wage law, and that our minimum wage was old minimum wage was in effect until 2020. That was 85% of this was for the miners. They increased the minimum wage for that. The tip wage hour was supposed to increase on 2020. What happened, just to jump over all this, was this is what was put into effect as of 2021. We had a new minimum wage that went to 12.48 an hour. The tip wage went up to 5.99. February 21st, 3.29. Tip minimum wage went up February 21st, and where it moved to is effective 12/21. Again, I don't know if there's any restaurants here, and I'll be honest, I've not had to deal with a restaurant and the tip minimum wage, but I do know this uh, uh, item where horse trading went on regarding whether restaurants would have to actually pay 100% of the minimum wage. That was the original law, uh, which meant they employ. Now the question is, the employer, the restaurants would have to pay 100% of the minimum wage, the new minimum wage back here. And the question is, what happens to the tips and so forth? Come on, where are you going here? So now we've got a little less movement in terms of the tip minimum wage. I defer to anybody who understands this. Again, I wish I worked more in the restaurant industry to understand this. But it's important because the restaurants were very much up in arms on the original law and got it amended to what you see here so that we don't have to, the restaurants do not have to pay eventually 100% of minimum wage, which is very expensive for them. Okay. Oh, come on. There we go. I think we got done kind of very quickly in terms of the time, but I wanted to leave at least 15 minutes open because a lot of this has been out there for a while, and what I've been getting is a lot of technical questions around, particularly ESTA, and I'd be glad to take them. I think the other question, Laura, that we had was, do employers with less than 30 employees, are covered by this? And definitely.
Yeah.
So I'll open it up to any questions.
Yes, thank you. Great memory. I had to backtrack to make sure we didn't miss any questions, but thank you. I mean, this is a wealth of knowledge and information, and again, as you mentioned, some things may still change just based on is it working or not, and it's really important for everyone to be prepared for it. As you mentioned, there is no ESTA police, but I feel like the employees will become the ESTA police if you're not prepared to
Oh,
answer
yes.
the questions and you're not prepared with backup, right? Documentation, post as much as
And
you
they're going to
can.
hear what they want to hear in terms of interpretation. So, okay, Mark,
Exactly.
hi, see your hand out there, Mark?
Go
Any?
ahead, Mark.
Yes, thank you, Michael. Very, very insightful. Brought down to a level that I can, for the most part, understand. So thank you for that. Um, my first question, I got a little lost in the words and the weeds relative to your last comment on nonprofit agencies. So the crossed out comment was, originally thought that we would be exempt, but at the end of the day, we are not exempt. We are still obligated to provide, this, correct?
Pursuant to Leo, a bunch of us think that interpretation is incorrect, uh, but we're not advising. We're actually, if you push me on it, I'll say, well, talk to your legal counsel. I'll put it on them. But the general consensus is, because of Leo's position, that nonprofits should comply with this law. Now, is there a grounds to say you misinterpreted this and this is not what the legislators meant? I know some of the advocates out there, like Michigan Manufacturers and SBAM, they're looking through the legislative history to see what was actually meant by that cross out.
Hmm.
I haven't heard anything that contradicts what Leo's interpretation is, though. So sorry to confuse, but that I thought a bunch of us, most of us on the employer side, and we're a nonprofit. You're a nonprofit. We're like, yay! But that was a short-lived
Let's
Yeah.
yay.
slow down. Yeah, right.
So I guess, I'm taking it as maybe it's better to be safe than sorry if we move down this path and it gets clarified by the Michigan Supreme Court, that we're exempt, then we can retract and stop all
Yes, sir.
efforts.
Yeah,
Okay.
we'd make it. We'd all us to be free to do what we want as opposed to what we're told.
Yep, yep. Okay. So then the next question I have, I took a bunch of notes and maybe we need to go back to the one particular slide regarding one bucket versus two buckets. So in the one bucket scenario, you talked about combining a bank of PTO from PTO to vacation to sick time. But then in the two bucket scenario, it seemed like there was some overlap, vacation, bereavement, broken car. I guess
Yeah,
I'm a little confused about that.
don't worry because you got to think in the universe of all paid and unpaid time off there. Uh, Used to be easy, I think, when maybe Mark and I got in the business. Employers said, "Well, here's your paid sick time, and here's your vacation time, and we're going to give you a little 2 days off for personal time." There was a third thing. A lot of employers went to these paid time off systems where they threw everything together and said, "This is what we can afford to put in that bucket for vacation, for anything else." With the two bucket system, because ESTA is so prescribed, um, the idea is just going to put the ESTA hours in that bucket, and then you got to think of all the other paid time off situations that you might want to give your employees a pass on, paid or unpaid, and as well as the vacation time off that everybody these days would expect a little bit of. So that would go in the second bucket. And under as a fringe benefit, employers can state anything they want around what they provide in terms of time off, paid or
PTO.
unpaid. You
Okay.
have to be concise because there's another law out there that dictates fringe benefits in Michigan called the Michigan Payment of Wages and Fringe Benefits Act. And this law basically says, hey, if you don't have anything going on, we have nothing to say about it. But if you provide benefits and you state that formally, we're going to enforce that formal policy against you. So you got to be careful in that bucket where you're putting everything together because ESTA requires you to do that carryover. It has it may have a lot of criteria to it that you might not want with your vacation and other paid time off policy. And I know I'm getting kind of vague there, but there are so many different, as I said, there are so many different fringe benefit policies talking about unpaid time off that if you throw it into one bucket, be careful how you differentiate ESTA, which requires you to follow the ESTA law, and how you would want the rest of the benefits treated. Let me give you a big example. A lot of employers will, upon separation, and the law says you don't have to do this, but you as an employer might say, hey, we're going to pay out any unused vacation and so forth. In the situation when you're using the accrual method, as I said originally, the employer will, in essence, accrue indefinitely for ESTA purposes. It's capped for use. But what if you mistakenly say, oh, I'm just going to, follow the ESTA accrual? And then you have a policy over here talking about separation from work and the fact you pay out unused PTO generally. Now you've opened the door to that employee argue, say, hey, I had accrued 40, 50 days of because I never took it. And you said you'd pay out all that. The law would be on their side. I
Yeah.
don't see this as a big issue, but I do always bring this up because I think people don't understand the Michigan Payment of Wages and Fringe Benefits Act and what it actually does. And now you've got ESTA to kind of muddy up that side of the issue.
Okay, thank you. That helps a bunch. One last question. Sorry if I'm consuming
That's okay.
other opportunities. My last question is, are there any obligations of a business to report anything to the IRS annually? Not anything related to ESTA?
No,
Okay.
no, no IRS implications. Um, I'm just trying to. That's the first time I've had that question put up to me. I'm just trying to think how some creative government bureaucrat could try and suck this into
Yeah.
it.
Yeah.
But if you think about it, these are what the taxes will be paid when the employee pays out the ESTA time, right? I'm taking this time off. It's going to be treated as normal income to get simple here. So that's already been taken care of. And the employer, of course, it's a personnel expense. They would get the expense on their side too. So no, there's no tax tax issues
Okay.
involved.
Thank you. That's all I have.
Okay.
No, those are great questions, Mark. I do have two other questions that came through as well. I'm gonna start backwards here because I think this one has already been answered, but just in simplest of terms, and the question is ESTA in addition to existing PTO?
No, it doesn't have to be. And this is a big employee relations concern with employers with a small vacation benefit. How are they going to add ESTA time or are they going to take away from the vacation time provided? And a lot of employers with, particularly in the first year of employment or second year of employment where the person isn't by seniority getting a lot more in terms of vacation time, what are we going to do with ESTA? Can we afford to add that on to the vacation or the PTO that we already have or the whatever? Or do we basically rob the vacation bank and give it to them as ESTA? That would be probably a good argument from an employee relations standpoint to use a one bucket approach. That way, you're like, hey, you got this, you can use ESTA for vacation just as but now but just be careful
Okay.
because people will do what you pay them to do, and if you don't realize what you just gave, you might not have thought of what they think of.
Yeah, absolutely. Okay, one more question, and then I'm going to stop recording for those that maybe have questions and are waiting for the recording to stop. Does ESTA change attendance policies and PTO for union workers?
Oh, I did not know if we had any union people here. I should have been so presumptuous, but ESTA does address union employers. What it did was the simplest part of this is it said if you've got a current collective bargaining agreement that in any way addresses sick time and so forth, that term and that contract can stay in place as is until the collective bargaining agreement expires, and then it has to catch up to ESTA in the next contract. Okay, so
Okay.
that's the main part of that law, and I'm just trying to think if it says anything else. Oh, if your collective bargaining agreement does not in any way talk about sick or uh, paid time off, then ESTA has applied. That's a Leo position, and that has been challenged by the unions. About wait a minute, you can't. What they're saying is under the National Labor Relations Act, you can't tell us what our collective bargaining agreement says. So there's a little bit of you can tell there's a little bit of Schadenfreude on my end here, where the Leo is basically getting in front of their the unions there and trying to change national labor law.
Okay. Thank you. I know adding the word union just drives another wrench into the complications, complicated questions. But thank you so
Follow
much for
your
addressing.
contract. Follow your
Yeah, follow
contract,
the
and
contract.
everybody up but Leo will be happy.
Okay, perfect. Okay, so before I stop recording for anyone that wants to ask questions, can you just tell us a little bit more about what ASC offers for businesses, for employers? I know it stands for American Society of Employers, and I just want everyone to understand what kind of resources you offer as an organization as well.
Well, thank you very much. Yeah, I'll be glad to try and put this into a 1 minute or less thing. ASC is a 122-year-old management association. So you heard right when you picked up that I'm on the employer side in a lot of things, to put it nicely. What
Mhm.
what we do is we provide support to employers in the areas of human resource. Uh, this is, all your policies and practices, compliance, the 60, 70 federal laws and the 50, 60 Michigan laws that apply to employers. We help our members every day navigate those. We have an educational arm that's focused mainly on leadership development as well as human resources. And we have a consulting arm. So we can provide, we got a little three-legged stool there around ASE where you get information, networking under the membership, you get education under the public and custom training, and then you get consulting. We can actually come in and do a hands-on development. For example, I review employee handbooks, and we also have part-time HR people that you can engage with, and on and on there. So I don't want to take too much of the program. I appreciate you asking that. And I'd love to talk to anybody who wants to learn a little bit more. It's a great service. Our big family jewels are all the compensation and benefits data that we collect from our members and publish in surveys that allows you to attract and retain your employees.
Thanks, Mike. Thank you so much. And I'm sure this will be first of many collaborations, at least with our team. I know you've done it in the past with the organization, but I'm so glad that we connected. And I'm sure this is first of very many workshops that we're going to bring to our members. So with that being said, thank you everyone for joining. If you're watching this recording, reach out to us for any information. I am going to be sending out a survey to those who attended with Mike's information and with their website, just so you could see what kind of resources they have. So thank you for watching, and I'm going to go ahead and stop recording.